of hearts is high. Things are mending now. I see a rainbow blending now. We'll have a happy ending now, taking a chance on love.
Concerning the undergrounding of utilities and prescribed time limits to rebuild non-conforming properties damaged or destroyed due to natural disasters, i.e. fires in this case.
Good afternoon, Chair Williams and Committeeman House. My name is Chris Hansen. I'm supervisor in the Building and Safety Division of the Community Development Department, and we have two amendments before you today. They both are promulgated in main part by the T-Fire and Jesucita fire disasters, and based on the challenges experienced by some homeowners affected by these fires as they have gone through the rebuild process. The first amendment that we're proposing for the reconstruction of damaged non-conforming structures, the current ordinance authorizes reconstruction of non-conforming buildings or structures, and that the reconstruction must commence within 1 year. Excuse me. Our ordinance would extend that 1 year to a period of 2 years after the date of the disaster, and replace the wording of reconstruction, clarifying it to say that it's the issuance of a building permit. The amendment also would remove the timeline that it says it must be finished within 2 years, and to allow the building permit process timelines to govern after the permit has been issued. We have statistics on the number of victims that have come in through, and if you would like to have those, I'd be more than happy to give those to you. But it's fairly simple. What the amendment is to extend the initial commencement, getting the building permit within 2 years, and then allowing the building permit to govern thereon. The second ordinance amendment is for the undergrounding of utilities. Currently, if a structure is rebuilt or a new structure is built, the ordinance requires that all of the electrical, TV, telephone utilities be placed underground, and only gives a few conditions under which that they don't have to do that. And in all cases, they would have to pay an in lieu fee equal to at least 5% of their project valuation. There is no exception in there for the loss of a structure or building due to a natural disaster such as the T-Fire or the Jesucita fire. And there are instances, especially in the T-Fire, where Edison has expressed a desire not to have the overhead lines be put underground due to the instability it could potentially cause for the power poles if the power pole is above the house. Even granting this waiver, though, right now we don't have any way to grant a waiver of the in lieu fees. So this amendment would state that if, in fact, Edison has reason to object to the undergrounding of the utilities, that we could grant that waiver and also grant the waiver of the in lieu fees, which we don't currently have.
Any questions from the committee before we go on to public comment?
I have one. There's a requirement that's added that has to do with the or perhaps adapted about the net square footage of the replacement building or structure, and that seems to be a fundamental criterion for what you're talking about.
Correct.
Okay.
If they don't build it like it was before the disaster, then they would go through the normal process.
With the normal requirements.
With the normal requirements
okay.
of the ordinances.
Got it. Okay. Thank you.
Take public comments. I am sorry to tell you, just because of how many people are going to be here, that we were going to have to limit public comment to 2 minutes because we have this many on the next item. If you go a little over, I'm not going to cut you off in the middle of a statement, but please keep it brief. Roy Hanthorn, followed by Lori Bonio.
Excuse me
Hey,
for
Roy.
not jumping up. It's Roy Hawthorne.
Hawthorne, sorry.
That's okay. First, I want to thank Mr. Williams for inviting some of the affected folks that I'm representing in the Conejo Road area. First off, I'm representing today Charles Wood, who lives on Eland Place, who is teaching a music class at the moment and couldn't be here. First off, Mr. Wood and myself support the amendments, and however, we'd like to see the Title 28 portion of the reconstruction of non-conforming buildings expanded to include existing homes in the Conejo Slide area. And the homeowners are working with the city presently with geologic information to support that. And we don't necessarily expect you to do that today or in the immediate term with the amendments that you're currently processing. However, I should report to you that the Conejo Slide Ordinance was based on a 1984 report with 9 borings, and the new report has a total of 20 excavations, and its basic findings are that the depth of the slide is roughly 1/3 of what it was thought to be before, and roughly 2/3 of the area. So there are many homes that are currently prohibited from rebuilding, which the new report supports being rebuilt. So when you're considering expanding nonconformancies for fire rebuilds, it seems prudent to put this group of folks out there in front as a particularly aggrieved party. These folks have lived there much of their lives, from anywhere 20 to 40 years. They are not ones that would be subject to some kind of buyer beware situation. They have lived there through the beginning and have experienced all this in great depth. With that, I'm going to give any time I have left to the homeowners, who are the ones that are particularly interested in seeing allowances expanded for their nonconformancy in order to do a basic rebuild. They'd be happy to underground their utilities. They'd be happy to even abide by other newer code requirements. However, just the basic right to rebuild, given the fact that their geologic investigations support that, seems to be something that the Ordinance Committee should have out there in front. Thank you.
Thank you, Roy. Lori, followed by James Tobin.
Hi. First, I'd like to thank you, Mr. Williams, for emailing me about this meeting to begin with, so we are all aware of it. And I'm just here to request that the amendment be extended to the Conejo landslide area MSC, particularly now with a new and more thorough geological report that is currently under review with the Building and Safety Department. And this report shows that the boundaries that were in question on the original report truly were questionable, as the original geologist stated in the said report. This boundary line, which was riddled with question marks, was used to define the homes within or partially within the Massey area, which is what my home is, in the partially area. And to add further evidence to the validity of this report, our home has not wavered in any landslide movement at all. And if not for a careless act in which a major fire destroyed our home, we would still be in it today. In light of this new information, it would seem reasonable to include the Conejo Massey area homes as non-conforming. And as it was imposed onto us to have borings and trenches analyzed on each of our individual properties, it would only seem fair and reasonable that these ordinances be modified to declare that each property also be individually reviewed on its own merits. Thank you.
Thank you, Lori. Our last speaker on this item is Mr. Tobin.
Williams, thank you for letting us know that this meeting was coming on. My name is James Tobin. I live on Conejo Road. Everything that Laurie said, I agree with. The other point that I'd like to make is when you talk about rebuilding on the same footprint, if an ordinance that you have for this Mass C slide says that you have to build 25 feet from whatever magic line there is on the charts, does that mean that we have to go through all this process of having to rebuild because we have to move our footprint 25 feet away? And if that is the case, then it's totally unfair. Even though this was not a natural disaster, this was man-made disaster, this fire. And it just seems like we are being criminalized far worse than the people who burned all our houses and destroyed so many lives, not only in the city but in the county. I don't understand why this process is affecting us so badly. I can understand zoning, I understand all of that, but I don't understand why people can just put maps and put lines on maps and say, I've been in my house for 44 years. 44 years. I know where the slide is. I was a fireman in Montecito. I have a certain amount of knowledge of things. And I would just hope that you guys would take this under consideration when you go and pass this ordinance. Extending it for 2 years, that's minimum. For the simple reason, the hoops that we have to jump through. We've been in this process for 10 months now. And we still just about in the same starting spot we were. So 2 years doesn't sound like a whole lot of time for me. And everybody that I know want to rebuild up in where their homes were. Thank you very much. And again, thank you for letting us know about this meeting.
Of course, Mr. Tobin, thank you for your comments. I'll just say, oh, we have one more on that item? Okay, please, come on up.
Again, thank you for inviting us to this meeting, Doss. But I kind of reflect basically what everybody has already said in supporting this, the provisions of this amendment to extend the boundaries and everything, and for you to look a little deeper into to what we've discovered with the Grover Hollingsworth Associates, a geological report, to see exactly what is going on versus what the city has done in 1985, to see the differences that we've discovered with this report. So I'll make it short. You know, I believe it's time for the politics to get out of this, and it's time to get realistic about really helping us. And that's basically what I got to say right now. So thank you.
Thank you, sir. And I can speak for myself that I would definitely be willing to look at extending this further if that was necessary. We do have some time to do that. And I think what the state is in right now is that my understanding is that the neighbors have commissioned a study to try to gather more information that might give us a more complete piece of information on what the state of the slide is, and that your folks are evaluating that and have asked their experts for some information, and you are now awaiting some responses from the expert that they hired. Is that basically the current state of things, Mr. Estrella?
Yes, Chair Williams. Currently, our consultant, Mr. Frank Kenton, has reviewed the Grover Hollingsworth report, has several questions and items that need to be substantiated and provided. At this point, there's no concurrence or disagreement with the report. It's a matter of getting clarification and further information as to how this opinion was derived at. I would say that given the questions asked, there are some discrepancies within the report that are very substantial that need to be rectified one way or another. So that is the process currently. We are awaiting a response from the Grover, the Hollingsworth folks to respond to those questions. We want to allow our consultant time to review those responses. And if there's some areas of questions or further clarification, I believe at that time would be appropriate to come together and kind of work those items out. That's where we're at today.
Chair
as,
Williams?
As chair of the, yes.
I just want to clarify before this conversation continues regarding the Conejo Slide Ordinance. That is a separate chapter of the municipal code, and this ordinance is not directly related to that. And I just wanted to make a note that there are actually probably 170 properties, a small subset, the Conejo Road, that could be affected by this ordinance. And we have a number of people in various stages of the process as the one-year time frame for November is approaching. So the timeliness of this actual ordinance it is not specific to the Conejo Slide at all, actually is a timely matter. And the Conejo Slide matter has not been initiated or considered as part of this ordinance. That's a separate effort that's being done by the building official and the city attorney.
Yes, I mean, I would agree that we shouldn't slow down this allowance that we're proposing to give victims of the T fire. I mean, they're obviously, many of them are experiencing hardships rebuilding, and we should proceed and pass on these ordinance amendments. But I do want to just say, as chair of the Ordinance Committee, that I am open to looking at this issue once we can get some of the technical wranglings ironed out. I believe that though our level of concern for this area is very, very high, we are open to further information and should evaluate further information. And of course, my heart goes out to the people who are having to wrestle with whether or not they're going to be able to rebuild their homes. That is just a terrible place to be in general. So I think that we should pass the ordinance changes as is, but be open to examining other suggested amendments once the technical discussion is concluded about the slide.
Mr. Chair?
Yes.
Could I just want to be real clear about this and follow up on what Ms. Weiss said. This ordinance has nothing to do with the Conejo Slide. It has everything to do with homes damaged in fires or floods or any casualty like that. Of course, we've had the T fire a year ago, almost a year ago, and now we've had the Jesucita fire. It's going to impact people who lost those homes, their homes in those fires. It is not only for those, because it would apply in the future as well. But this ordinance has nothing to do with the Conejo Slide area. And any reconsideration of the Conejo Slide area ordinance, which is, I think, about 24 years old, has not been initiated by the City Council. The Ordinance Committee hasn't been asked to look at it, which is required by the municipal code. So there's been, all we have is a report, a geological report that we received. We referred to a consultant, Mr. Estrella referred to a consultant, and the consultant had a lot of questions, more than several. It was, I think, 20 or so significant questions about that report, and we're trying to get those questions answered.
I think that's all appropriate, but I'm sure that if Mr. Estrella gets better information, that he would bring it back to the Ordinance Committee, and we could talk about this again. Okay.
Mr. Chair, what I was trying to point out was that this matter of reconsidering the Conejo Slide ordinance would need to be referred to the Ordinance Committee by the City Council as required by the municipal code, and that hasn't happened yet.
Very well. So but on the matter of the suggested amendments today, can we get do we have any discussion? Mr. House.
All right, good. A couple things. One, for Mr. Strayer or for your team here, you've said a year, and we've heard anecdotal evidence that it's taking much longer than people anticipated for insurance reasons and all sorts of things. And what provisions do we have, or would it perhaps even be prudent to consider a longer period of time? What provisions could we have in case there were somebody who got caught up in the snare? Because some of the stuff that's going on right now that is so out of the control of the individual property owner, it seems, at least. Could you just address that a little bit for us here? I mean, perhaps we'd come back again before the end of this next year and get a status report, or what would be the best way for us to approach that?
The ordinance provision for allowing reconstruction of nonconforming buildings has currently this one-year period. And that has actually been applied for decades and worked in many individual instances. I think we recognize the scale of these recent disasters makes it very difficult for the community as a whole and the organization to be as responsive as we might want to be. And the process has become more complicated over the years as well. So even for an individual case, 1 year is not enough time. And we do believe that in any instance, 2 years would be appropriate to retain the right to these nonconformities. You can always propose to rebuild or seek modifications if you can't conform after the 2-year period. And actually, of the number of homes being processed right now, we think that approximately a third of the projects are relying on these nonconformities. There are a number of homes and new rebuilds and new projects coming in that aren't needing to rely upon it. However, and we are trying to track them all individually and get them tagged and understand what's going on. We had talked about possibly building in some discretion into the ordinance that the community development director could, based on due diligence or something to that effect, and I'd like Mr. Wiley's comment on that, because as it's drafted now, we didn't include anything that would give some discretion to extend the time period. But as Committee Member House is saying, we could also just come back and make it 3 years. But I do feel that in most instances, 2 years would be enough time.
Mr. Estrella.
House, just to add to that, and just to again that once these projects are submitted to the building department for plan review, they potentially have up to an additional year to get the project through. And under the administrative provisions, even more so than that. So when you add up the time frame, it does provide a certain amount of time, up to possibly 3 years, as is or being proposed.
Okay, it's very helpful. And so I didn't see any wiggle room in here at all. It sounds like the real incentive is to get at least something started. I mean, get the process started, as you're talking about, Mr. Estrella. If we get to this point again next year, and in your assessment we really have a problem going on like we do right now, I would request that you arrange to come back to us so that we can have another conversation at that point, because I think the kind of things that people are facing right now, certainly there's good intention to get rebuilt, and we don't want anybody just lagging along, but I haven't heard much of that. It sounds like most people are really trying as hard as they possibly can. There may be other conversation, but perhaps it could be within the framework of a motion. And I move that we adopt this. That we move this to City Council for consideration and adoption, as it's written here in our staff report.
Is there a second? I'll second it. Mr. Francisco, discussion.
Thank you, Mr. Chairman. I share Mr. House's concerns about the time that it'll take people to get through the planning process. I believe that the bare minimum time it will take most people to get through this process, if they make no changes to their existing structure, is 2 years. And I think the minimum time for redesign is more on the order of 3 years. I personally know people who have abandoned their attempt to rebuild because they felt that the process was too daunting. So I think that 3 years should be the time. 2 years is not sufficient. And I can go along with this if it's 3 years. I won't support it if it's 2.
Mr. Chair,
Mr. Wiley.
I just want to make sure we're all on the same page, and if it's 3 years is appropriate, then that's what we'll do, obviously. But I understood there might have been some misstatement. The building permit has to issue within, as drafted right now, 2 years. So you don't have to have the home completed within 2 years. You have to obtain your building permit. So in the case of the city, under the single-family design ordinance, you've got to have your design approval from the SFDB and have issued a building permit. Then under the permit, you've got a time frame to complete construction. So just as long as we're clear about that.
Mr. Wiley?
And I should add, I mean, maybe it's more for the public. Anyone who's daunted by our process should think again, because in our experience, particularly with these rebuilds, we bend over backwards to make it doable for people, and I've just seen it myself. I know it appears initially to be daunting, but it really, in effect, isn't, I think.
Mr. Wiley, I'm glad you brought that up. And if the ordinance language had said, instead of building permit being issued, if it had said something about some level within the design review process being reached, I'd be okay with 2 years. But building permit issued means, as you've said, they've gotten all the design approvals. And I really believe that in the best case, that's going to be 2 years for most people in the fire area. And we've all seen, any of us who've been closely involved with the ABR and the HLC over the years, we've all seen cases where review stretches on for 3, 4, 5, 7 years. So that's my concern. I think that this 2 years to building permit is a best case scenario. And if we wanted to keep the 2 years and change the language so that it was some earlier point in the design review process, I could be okay with that.
Mr. Chair, I want to make sure, because I thought I had just clarified with Mr. Estrella that the entry level into the process, well, why don't you do that for us? What is the, there are having been on the Planning Commission, I've seen how projects that once they kind of get in the game, there are opportunities for extensions, and they're legitimate because there's legitimate things that happen. Talk to us again about this, this starting point for the clock ticking, or the ending point, I guess, of the...
I think there was some confusion that Mr. Wiley clarified is this ordinance, as it's drafted, the additional time and plan check would not apply, as Mr. Estrella explained. This is a certain period of time, currently 1 year, proposed to be 2 or 3, to the issuance of the building permit. And I think that we really should stick personally with the issuance of the building permit, because then we get into, well, if your final approval from the review board is done, then you have to keep that valid, and if that expires, it could just, I sense the right that they're trying to retain, the entitlement to rebuild a non-conforming structure is to rebuild it. So if additional time is what the committee thinks is necessary, I would certainly support doing that to the building permit. What Mr. Estrella was talking about is once someone submits for a building permit, submitting for it, that allows them up to, say, a year, or they have administrative ability for how long the building plan check process takes. This is saying at the completion of the plan check process, that would occur within 2 or 3 years. And I just need to make a plug for the Single Family Design Board. I mean, they have worked very hard to address the needs of the people rebuilding, and we have 57 final approvals to date, and that's been in a 10-month period. And so we've been very responsive, but I do think that there are these cases that Committee Member Francisco is talking about, and some people face real difficulty. So that was why I was wondering, should there be anything built in for those few cases where there's a lot of difficulty, but certainly would support a reasonable period that you believe is reasonable. We have had people, 42 of the 57 have now progressed to building permit being issued. That's still a little over a quarter of the number of people. So certainly this is needed, and we would support a 3-year period to the building permit issued if that's what you'd like.
Well, if the staff supports that, I'll amend my motion for 3 years. It'll be actually 2 years. It'll make the total from the fire a 3-year period.
So essentially what we would be doing is extending the time period for 2 additional years for a grand total of 3 years tied to the issuance of the building permit. I can support that. That's, my way of thinking is that if we're wrong about the 2 years, if we're wrong about the 3 years being sort of a bad mechanism, the worst thing that happens is a couple properties take longer to get into gear and get things done. If we're wrong about 2 years being enough, a couple people are hurt severely. So I think one of our principals should decide on the side of doing no harm. So I think 3 years is appropriate. So the motion is that as the seconder of the motion, I agree to changing the motion to 3 years. We have a motion and a second. All those in favor, please say aye.
Aye.
Opposed? None. Motion carries. Recommendation will go to council. And we have item 2, medicinal cannabis dispensary ordinance revision, the main event. Mr. Cato.
Good afternoon, Chair Williams and Ordinance Committee. My name is Danny Cato. I'm a senior planner with the Planning Division, and I'm here to give the staff presentation for this item. As you said, we're here to talk about revisions to the medical cannabis dispensary ordinance. I'll run through essentially my staff report, and we'll have some additional input from Captain Armando Martel from the Police Department. So the purpose today is to review the existing ordinance, discuss some options, and direct staff on potential revisions. For a little bit of history, on August 14th, 2007, City Council directed staff to prepare an interim ordinance that would prohibit new dispensaries for an interim time so that the city could come up with a permanent ordinance. On October 3rd of 2007, that interim ordinance was adopted. March 25th, 2008, Council adopted the permanent ordinance, which I'll just refer to as the current ordinance. And that became effective 30 days later, April 24th, 2008. And July 28th of this year, Council directed the Ordinance Committee to look at potential changes to that existing ordinance. The current ordinance has locational, operational restrictions, and the request is heard by the staff hearing officer. Currently, dispensaries are allowed in the C2 and CM zones, allowed on Outer State Street between Calle Laureles and Calle Real, allowed on Milpas between Carpinteria and Cana Perdido, and within 1,000 feet of Meggs Road on Cliff Drive. They are prohibited within 500 feet of schools, K through 12, parks, and other dispensaries, and they're prohibited on State Street between Highway 101 and Arriaga. I'll show you some quick maps. This is a citywide map that shows the areas that I just mentioned. The first map is the downtown map, and let's see, this kind of pinky area here is the area where dispensaries are allowed. The State Street prohibition is shown in brown here. Parks are in green with their 500-foot buffer in light green. Schools are in blue with their buffer in light blue. So you can see where it covers up, it gets kind of a weird pale pinky color. So this is State Street. Now I show some existing and pending and proposed dispensaries on this map as well. On Milpa Street, again, Milpa Street is here with the pinky areas where they're allowed. 2 dispensaries that are permitted. Again, schools with their buffers and parks with their buffers. Upper State Street is right here, going down De La Vina Street. Mackenzie Park and Peabody School kind of put their buffers around this part of State Street. And that's an existing non-conforming dispensary there. And the Mesa, this is the Mesa Shopping Center. This is Meggs Road and Cliff Drive here. So the current ordinance has a bunch of operational restrictions. You can just read those. I'm not going to say them all, but they range from, a floor plan that has to have a separate dispensing room, through operational plans, prohibitions on selling paraphernalia, et cetera. And the current permit processing, like I said, this is heard by the staff hearing officer. It is appealable to Planning Commission, but not appealable to Council. The approval is valid indefinitely as long as it's the same owner and same location. However, there is the ability to revoke the permit if the dispensary does not comply with their restrictions on the ordinance. There are a number of approved and pending and non-conforming ordinances. 331 North Milpas is the only one that's approved and operating. We have 3 that are approved, 500 North Milpas, 631 Olive, 2 West Mission. And we have 5 that are pending on Chapala, 2 on Haley Street, 234 and 302. Only one of these would be allowed to move forward because they're across the street from each other. 826 Delavina and 430 Chapala. Non-conforming ordinances are those that were in existence prior to...
Mr. Cotto, I missed that last point. Please,
Okay.
please go back. So only one of which 2 pending would
Sorry,
be allowed to go forward?
Vitamin M Collective at 234 East Haley and Aloha Spirit Organic Consumables at 302 Haley. These are, they both put in applications, but only one of them can exist because there can only be, there's a 500-foot prohibition between dispensaries right now.
Okay.
So the way we're handling it is whoever gets deemed complete first gets to go forward and gets their first shot at it with the staff hearing officer and through the process. And if they get approved, then the other one won't be able to go forward. But if they do get denied, then the other one can take their shot.
Okay.
Non-conforming are ordinances that pre-existed the interim ordinance, and we're able to document that to the city's satisfaction. There are 4 of them: 3516 State, 27 Parker Way, 100 East Haley, and 3128 State. The first 3, actually, we have zoning enforcement cases. We are trying to verify their conformance with, if they're really non-conforming, if they've met all the requirements to maintain their non-conforming status. And then there are a couple that we have illegal or under dispute, 2915 De La Vina and 336 Anacapa, and then there's others that are being investigated by the police department. So there's 14 issue areas that were in the staff report. I'm not going to read them all off, but I do have a slide on each one that'll go through quickly. 9 of them, the first 9, were requested by the council for the ordinance committee to look at, and the rest were brought forward by staff after processing several applications. We thought of some issues that we'd like to see addressed or discussion had at least. So the first issue area is the police department statistics. The council asked the ordinance committee to look into crime statistics around dispensaries. And so we have Captain Armando Martel from the police department to talk about crime statistics and calls for service.
Chair and committee, marijuana is still illegal federally and through the state laws, other than the Compassionate Use Act. So that's where the dispensaries actually fall in under that provision. But we still are doing investigations for marijuana. And as you can see, in the last 18 months, we've done quite a few. But majority of those cases are possession of less than 1 ounce. Even through Measure P, we still have arrested and cite and released 423 in the last 16 months. We've also done 4 investigations on possession of marijuana on high school campuses. But I'm aware that there is nearly 60 internal investigations done by the school themselves there at Santa Barbara High School. We've done 2 cultivation cases that just recently netted almost over 700 pounds of marijuana that was an illegal grow just outside of the city. And that's in 2009. In 2008, we had 46 pounds of marijuana. Most of the large marijuana grows are outside of the rural areas and in the county areas, but we work jointly with the Sheriff's Department to eradicate those. But I thought it'd be appropriate to bring up the offenses through reporting districts. In our reporting districts, there's a little over 60 of them, but I thought it'd be important to bring up at least the top 10 because that's majority of the Part 1 crimes occur in the top 10. Everything else below the top 10 is either 2% or less. And using the Part 1 crimes is really kind of a standard through this state and federal because those are the people that we report our statistics. So the Part 1 crimes are as stated up there, which is homicide, rape, robbery, aggravated assault, burglary, larceny, which is thefts, and auto theft. So those are the ones that we use as Part 1 crimes and we report annually. So that's the breakdown of the reporting districts. There's 10 there, but as you can see under the area description, the majority of these are in business districts, the ones that we authorize under the original ordinance. We're looking at the downtown area, downtown business district, the Milpas area, the beachfront. We're also looking at the upper State Street business area. So that's quite interesting that that they are in the top 10 of the reporting districts. I also incorporated, which is not Part 1 crime, but I thought it was appropriate here, was the marijuana under 1 ounce cite and releases, and that's a breakdown through those reporting districts. And again, majority of them are going to be in the downtown area, and then the beachfront as well. And then Milpas came down to like number 4 under the marijuana, under 1 ounce. There's also other that are not Part 1 crimes that I also incorporated in the last column to your right, and that's the Part 2 crimes. That's everything that's not incorporated in Part 1, and those are all other crimes. Generally, they're nuisance crimes and so on. And that's a breakdown of the actual reported offenses that we have for the last since October 2008. The dispensaries. I know Mr. Cato mentioned all the different dispensaries, but the approved one on that's actually running is 331 North Milpas, and that one has had 4 calls for service. They're really non-descriptive calls. The only one that really pertained to that one was one call where they had a person that didn't want to leave, and they called the police, and we escorted them off the property. And that's in the Milpas area. Under the non-conforming is you have the Upper State Street. You have 2 of them. Both of them don't have calls for service. They're in different districts, but they're joining next to each other. Then you have 100 East Haley. That one is that one's right at the intersection of 100 East Haley, and it created a problem for us in regards to calls for service. But we can tell basically there doesn't appear to be any calls for service pertaining to the dispensary, but when it's classified and addressed on a 100-block zone, it picks up all the calls at that intersection. It's a busy intersection, so anytime anyone calls at Anacapa and Haley or 100 East Haley, it could actually be applied to that address. But what we can see, based on our new computer system, that there isn't anything pertaining to that dispensary at this point, but we still put undetermined. And then Parker Way, that one has had 8 calls for service. Half of them are really nondescript calls, but the other 4 were pertaining to a call where there was a robbery there and a extortion related to the owners. So we've resolved that and made an arrest, and that's actually going through court now. Also should probably note that we drove by there this past week, and it doesn't appear to be open at this point. It may be vacant. So we're going to look into that fact. But 4 of those calls were on the same call itself, from various people calling in that one call for police response. Okay. On the approved 500 North Milpas, that hasn't opened up. There is no calls for service. Again, that is going to be right at the intersection. 631 Olive Street, same thing, hasn't been opened up to West Mission, but we've already checked those and looked at the crime statistics, and we've approved them at this point in time.
Thank you. So the second issue area is a cap on dispensaries. So should there be a cap? If so, what should the number be? Should it be citywide? Should it be geographic area? And if it's by geographic area, what should those be? I divided up the mapping into 4 areas: the downtown, Milpas, Upper State, and Mesa. There is a citizen-sponsored ordinance amendment proposal that proposes a cap of 4 citywide, with 2 downtown, I think 1 east of State, 1 west of State, 1 in the Upper State area, and then 1, I think, on Milpas. I can't quite remember. So there's a bunch of different methodologies on dividing this up or determining where they're going to be. And then another question, if there is a cap, if it's less than the current number that are approved, then what do we do? How do we determine which one of those get to stay, or do they all get to stay? You know, there's some questions involved with the cap. Like I said, there's a bunch of operating restrictions. There's a bunch of security requirements. We as staff thought it would be appropriate to add a couple One is hours of operation of 10 a.m. to 7 p.m. The other is a licensed security guard through the state. These are conditions that have been put on the last few dispensaries that have gone through our process. There's a suggestion to not allow dispensaries in the proposed Milpas recovery zone, and that's an area that's sort of around the Casa Esperanza homeless shelter. This concept and the boundaries have not been finalized, but suggested boundaries are Milpas, the beach, Garden, and Gutierrez. And if this area were to be restricted, that would cut off a good part of Milpas Street. Another is proximity to schools, parks, etc. Like I said before, right now there's a 500-foot prohibition between schools K through 12, parks, and other dispensaries. There are options. You could increase that to 750, 1,000, a quarter mile, half a mile. You could make a prohibition between X number of feet of residential zones. You could include other things that would drive a buffer drawn around them, like preschools, daycares, alcohol rehab, that sort of thing. The consequence, though, is that you limit the areas that they're allowed, sometimes severely. And in order to show that, I have a couple of slides. Again, this is the map you saw before, downtown area, 500-foot buffer around schools and parks. If we go to 1,000, you can see that it limits quite a bit. Can you see that, how we go back and forth? And if you added preschools and churches and daycares, basically there would be no area where it would be allowed, I think. Next is the amortization.
Mr. Cato, because you're on that issue, and sort of the question would be, well, then what bad does that do if it further limits it? The concern is concentration, then, as a consequence to limiting it further spatially, then that leads to many places closer to each other. Is that the concern?
Well, the concern of
concentration.
Yeah, the concern of concentration right now, there is the 500-foot prohibition between. There are concerns from the public about that's too close, right? And also that 500 feet is too close from parks and schools and other potentially sensitive uses. And I'm just trying to illustrate that if you, even if you just take schools K through 12 and parks and you make it 1,000 feet, then you're just
essentially banning it.
You're just restricting it to a very small area, and that area could be so small as to be non-existent, depending on how it were to be formulated. So I'm saying if you made it I have some other slides that show even a bigger distance, and I can show you that if you're interested. But let me just continue because I have a little ways to go. The next subject is the amortization period. The existing ordinance has a 3-year period from the effective date of the ordinance, so that would end April 24th, 2011. Options are to change that, to not change it and let it be, or to reduce it. There are impacts to neighborhoods. We have had anecdotal evidence, and we've also had some police reports that describe some of these impacts. There is a white paper on marijuana dispensaries that was prepared this year by the California Association of Police Chiefs. I think you got that in an email. And so there have been in the state of California, and even here, violent crime, loitering, smoking in the vicinity, illegal reselling of marijuana, graffiti, and other sort of neighborhood non-friendly items. And I'll have Captain Marchell give a little more on that.
Yeah, some of the neighborhood impacts, or really call it community impacts that we've seen, really just recently, as of August of this year, we shut down an illegal dispensary on the 1200 block of Cacique Street, and we made an arrest there. July of this year, there was a home invasion robbery where part of the motive was to steal marijuana, and that was on Oceano near City College. We made an arrest there. April of this year, there was a robbery and extortion, the one I mentioned, I believe, earlier on 27 Parker Way. Arrest was made there as well. May of this year, there was a burglary to a business, another dispensary on the 3100 block of State Street. And then you leap back to 07 when they originally some dispensaries came in, and there was some other action that occurred, some criminality on in 07 and on 22 West Mission Street. There was an armed robbery of a dispensary. 2915 Delavina Street, they were victimized as burglary. 3128 State Street, they were victims of a robbery. 816 North Milpa Street, a dispensary, not the dispensary itself, but one of the customers or the patient walking out was strong-armed and robbed there on Milpa Street. So as you can see, those things impact us throughout the community, and it's just not the dispensary, it's everyone around them. Yes, and anecdotally, you can say that a lot of people have complained and brought this to our attention, that it could create crime, whether it's real or perceived. But when we see these in the newspaper and arrests are actually being made, it impacts us all. So I thought I'd bring that up in regards to the impact of neighbors.
Next subject is the interim moratorium or interim ordinance or applicability to future projects. Right now, there have been calls from the public for a moratorium. Let's not let anything else go through while the Ordinance Committee and City Council goes through this process. As I understand it, a moratorium would be imposed by Council, would last 45 days, no public notice is required. But within that 45 days, we'd have to do a public notice and adopt an interim ordinance, like we did the last time. And that would give 12 to 18 months for the revisions to go through the process. And during that time, pending projects wouldn't be allowed to go forward. That's an option. One thing that the city attorney has told us is that whatever happens through this process, whatever comes out at the end, would apply retroactively to projects that are currently pending and anything new that's coming in. So that might be a way. So maybe a moratorium is not necessary. It's really a question for the Ordinance Committee. How do you want to move forward with that? And then another related question about this is, how will these revisions be applicable to existing or approved or pending projects in the end? Will they just become retroactive blanket to even to existing dispensaries? And if so, what if they're not in a location that's approved anymore? Or if something's pending, is it, do these revisions become applicable if they're not complete yet, or if they're not approved yet, or if a building permit's not issued yet? This is something that we will definitely need to nail down through this process. The council asked us to look at neighboring jurisdictions, and we did that. At this time, it seems like only the city and the county allow dispensaries. All the other jurisdictions that are listed there do not allow them. They're either banned outright, or they have a moratorium or an interim ordinance while they're going through a process themselves to determine what they're going to do. Now we're getting to some of the issues that staff wants to talk about, I guess. There are 13 criteria that are required, and if the staffing officer can make those criteria, and then they can approve the project. One of them is criteria 2, the high crime area, and it requires that the chief of police identify an area as a high crime area or not, and there aren't any high crime areas in the city, and we would propose to change that around a little bit to give the police a little more leeway to be able to say, this may not be a high crime area, but we still have concerns about this dispensary location. And the second is reporting requirements. This is sort of a vestige of when we thought there would be a renewal period, so I was considering to just delete that altogether. Discretion of the staff hearing officer. Normally, these findings the criteria were set up so that if the findings could be made, the dispensary permit would be approved. There are a couple of criteria that allow some discretion. We'd like a discussion on how much discretion the Ordinance Committee believes the staff hearing officer should have for these. And so there's no significant nuisance problems are anticipated, and it would not adversely affect the health and safety. So it comes down to a matter of trust. If we trust the applicant operators to do what they say they're going to do, then we wouldn't anticipate significant problems. But if we don't trust them, then you could anticipate them. How do we go about that? Lack of appeal to City Council. Right now, as I said, Planning Commission is the final arbiter of these. That has been a source of angst for some of the planning commissioners and the public. And so an option would be to change it or not, to let council be the final arbiter. Another issue that came up through the public comment was, hey, you're concentrating these dispensaries in our neighborhoods. How come they're not allowed in more neighborhoods? Like, how come they're not allowed near hospitals? It's a medical use. Why not allow them near Cottage Hospital? So that's an idea maybe. And then also to just kind of further reduce the intensity, maybe allow them on Coast Village Road, subject for discussion. And then lastly, full cost recovery for application processing. Currently, we charge $200 an hour for as long as it takes to go through our process. But that $200 an hour is probably not full cost recovery. We need to do a fee study to figure out what full cost recovery is, including overhead. And a question for the Ordinance Committee is appeals. Right now, an appellant, whether it's the applicant or a neighbor, pays a $300 appeal fee, and that's it. There's no other fees charged. But should the applicant pay the cost of processing that appeal? So recommendation today is to hear public testimony, review the current ordinance, discuss the proposed revisions, and direct staff to make the revisions. And the possible next steps is to, there's a lot of people here to talk. So we reserved 2 weeks from today another ordinance committee meeting to continue this discussion. And then we imagine we would go back to council for more direction, and then maybe back to ordinance committee, we're not sure. But state law requires the planning commission to make a recommendation, and then council would have to introduce and adopt the ordinance. That concludes my staff presentation. Thank you.
Thank you, Mr. Cato. And I, because we have 34 speakers, I'm going to do something that we have not done before, which is to not allow the committee members, meaning us, to ask questions, because otherwise we'll be taking away from, in all likelihood, someone from being able to speak, because we have a council meeting starting at 2 o'clock. So we have 1 hour for 34 people, which means that I will put a limit at 2, hoping that some people will take less than 2 minutes. And then at the end, if there's time, then each of the council members up here will be able to ask questions, or I guess in a rare instance, if we need to ask a clarifying question of a speaker, I will allow that. But for the most part, I don't want, because we often talk very long, that to take away from your ability to talk to us. And I also would ask people, the next person, to get up long before they're up to speak. So I will always tell you who the next person is. So we're going to start with Mr. Ruben Barajas, and followed by Robert Fedor. And if there's no Ruben Barajas, we'll start with Robert, and followed by Elva De La Torre.
Good afternoon, Chair, committee members. My name is Robert Fedor. I'm with Advantage Planning. I gave staff a handout from the Americans for Safe Access for your guys' reading pleasure later on. I wanted to commend you guys on what you've done. I work in a lot of different municipalities, and I feel what you've done, while you feel like you have problems and issues to deal with right now, you've done a great job compared to some of the other municipalities that I do the bulk of my business in. One of the things that I thought would be a great idea as a whole would be a Santa Barbara Collective Alliance, okay? And by doing something like that, what you do, it's very simple. What you do is all the dispensaries that are operating would have a small placard on the front door or front window with a hotline, a dedicated phone line. One of the dispensaries would take lead in that, and it would be much like a neighborhood council. You'd have a monthly meeting. The police, the local authorities would all be, the public would all be invited. You'd have a public comment period. You'd have an educational component, and you would address specific issues. And that way, the local government as well as the police wouldn't get inundated. In addition to that, you'd reduce a lot of the fear that neighbors have to some of these dispensaries by allowing people to have face-to-face conversations and work through specific issues. So I think that is something that you might want to consider. In terms of cost recovery, You might look at a model such as Los Angeles for conditional use permit in terms of beverages. They're at around 74-45 right now. It's kind of a tricky number. The other thing I might suggest is that some of these dispensaries not just be dispensaries, that you might look into having a nutritionist involved, an alternative medicine, massage, acupuncture, so it's not just a straight up dispensary. And then I would also, I'm not sure if you guys can do this legally, but I would encourage language that might help have some of the dispensaries give specific donations to the immediate community that they're in, whether it's helping to take care of the nearest park, donating to recovery centers, and so forth. So those are my comments. Thank you.
Thank you, Mr. Fedor. Elva De La Torre, followed by Kathleen Gu.
Hello. Good afternoon, committee members. My name is Elva De La Torre, and I am speaking today as a citizen of the City of Santa Barbara, as an advocate for the protection of our youth and homeless populations. I ask that you repeal the decision to allow the medical marijuana dispensaries. My concern is as a mother and a citizen for the youth and the homeless. Any location, in my opinion, in the City of Santa Barbara is unacceptable. Many of the youth roam the streets to hang out as a form of entertainment. On any given day, the youth could ask a homeless person to purchase alcohol for them for a few dollars. I believe the dispensaries would provide a venue for our youth and homeless to be exploited and harmed by allowing the dispensaries in the city through illegal reselling of marijuana. There are no definitive studies that indicate that marijuana for medical purposes has a value, and many of the medical organizations do not support it. Again, I ask that you repeal your decision to allow medical marijuana dispensaries in the city. Thank you.
Maybe Kathleen Go, followed by John Campanella.
Hi, my name is Kathleen Gu, and I work for the city as a commission secretary, and also am a resident at the Paseo Chapala building on the corner of De La Guerra and Chapala Street.
How's that for workforce?
Very well. Thank you. I'm going to concede my time to, I believe John Campanella is listed also. I'm going to read a letter that, unfortunately, Aaron Carroll, he's an architect for Arcadia Studio, and he wasn't able to attend, so I'm going to read his email. Dear committee members, as a resident of the Paseo Chapala building, I strongly oppose the medical marijuana dispensary proposal. He does not oppose the opening of dispensaries in general, just the ones for multi-use buildings included in the C1 and CM zones. C2 and CM zones. The ones currently open for business are located in inappropriate areas of town. Some make sense, but others in commercial and retail zones do not. However, if this project is approved for multi-use buildings, it sets a terrible precedence for future marijuana dispensary proposals in Santa Barbara. If this proposal is approved, will we be saying it's okay to have these types of establishments within a few steps of children, families, and residential dwellings? This would be the first dispensary in town that is close to residential dwellings, and think about the precedent that this kind of project would set for the community. Parking concerns. The customers of dispensaries will no doubt park illegally in residential spaces in multi-use buildings. This amount of parking we have in our building, Paseo Chapala, simply cannot support a high turnover establishment such as this. The former city council member and architect, Gil Garcia, is an architect for two dispensary proposals in town, and he supports this proposal. However, he told Mr. Carroll personally that it's just not right for an establishment such as this to be proposed in a mixed-use building. One of the dispensaries he is working on is located only at 1.5 blocks from Paseo Chapala.
You've got to wrap up.
Okay. He can't speak, Mr. Carroll cannot speak for all the residents of Paseo Chapala, but it would be safe to assume that an appeal of an approval to this concerning a project like this to the City Council could be considered. If this project does get approved, store hours would be critical, and hours should be limited from 8 to 5. Thank you.
Thank you, Kathleen. John Campanella, followed by Brock and Maria Dumont.
Good morning. John Campanella. I am here as president of the Paseo Chapala Residential and Office Association. Those are residents who are really on second level, non-retail residents, both office and residential, and also the garage below. That's that association. Separate association for the retail, who I'm not speaking for. Just a couple of points to follow up on. The current ordinance, not to be maybe needs to be more clear, but to me, the current ordinance does not allow dispensaries in any parcel on a parcel zoned for residential use. Okay. Now we can get technical and say there's not a mixed-use zoning, but we have a completed residential units on this property. Okay. So I think we can say it's residential and it's allowed for residential and it's been approved. The dispensary below would be within 16 inches of a residential neighborhood, not 1,000 feet or 500 feet. This is close enough, and I don't think other residential people would like to have a dispensary so close to their own property. What we would propose is that this be clarified, that existing residential development or planned or in the approval process for a mixed-use zone downtown, the consideration be that dispensaries are not allowed in that particular property or that particular building, that particular parcel. Where it is zone C1, and it has no other development or residential development on it, we support the fact that it should be available to the public. CO designation, like the hospitals, should also have this available, and we're in support of that. The second issue is really security. In mixed-use buildings, you're going to have a mixed use of garage space. You have conjunctive use, you have unsecured garages, you have people coming all times of the day and night. I would think one of the intents of a dispensary is that if it does have parking, it's secured, and it's secured for that use only. I question, let's say, State Street. On State Street, we don't allow dispensaries. I don't know if that's due to the fact that you can't have secured parking, you can't watch where people are coming and going. I don't know the background. But a mixed-use building parking is
John,
also
you got to
a
wrap
problem.
up.
So we'd like you to consider not allowing dispensaries in mixed-use existing or planned structures. Thank you.
Brock or Maria Dumont, followed by Scott Bondurant.
Hi, I live at the Paseo Chapala. It's the mixed-use building that we've been talking about at the intersection of Chapala and De La Guerra. This mixed-use building consists of 29 residential family units, which are 95% occupied at the moment. There's a pending application for a dispensary to be located at our building. In short, my concern is mixed-use units may have been overlooked in crafting Chapter 28.80. The ordinance states the term premises includes the actual building as well as any accessory structures, parking lot, or parking areas, or other surroundings within 200 feet of the dispensary entrance. For a mixed-use building like ours, this would include the entire structure. The ordinance also has many provisions relating to security plans, surveillance, alarms, dispensary controls, site management, and notices, and then it outlines the many activities a dispensary operator is required to manage, including undue loitering, crime, illegal and nuisance activities, since these are known activities attracted to businesses that dispense marijuana, presumably. You can see by the photos that I've submitted some materials that you'll get to look at later, the complexity and how overwhelming this would be for a marijuana dispensary located, or for a marijuana dispensary operator to effectively manage at our location. There are lots of parking areas, nooks and crannies, tremendous sidewalk space, and not to mention the residential area. One lapse by the operator means 29 families are affected. This doesn't consider the consequences of a federal raid on our property. I feel locating a marijuana dispensary at a mixed-use premises like ours proactively brings many risks to the families living on the premises. What I'm asking the City Council to consider is taking another look at the ordinance and to restrict marijuana dispensaries from locating at or within 1,000 feet of a mixed-use residential building. In terms of access to medicinal marijuana for patients, I printed out a weedmaps.com website that shows that there are 3 locations already within a 4-block radius of our building. So it doesn't appear that access is a problem for people seeking this type of treatment. I've included that with the materials I've given you. I thank you for the time.
Scott Bondurant, followed by David Hughes.
Good afternoon, Council. Thank you for hearing me out today. My name is Scott Bondurant. I'm the Center Director for Girls Incorporated of downtown Santa Barbara. We're located at 531 East Ortega Street. We are a summer and after-school child care facility. And I'd like to state for the record that the board members, staff, program staff, administrative staff, and quite a few of the parents of Girls Inc. are strongly opposed to the operation of one of the approved facilities. The 600 block of Olive Street, the dispensary is less than 500 feet from our current facility. And I would like to second some of the suggestions that have already been made to include facilities such as daycare centers, childcare facilities, homeless shelters, and facilities such as Transition House, to include that in addition to schools within a 500 or even much larger radius. While we are not technically a school, we are open 350 days a year. That is quite a bit more than your typical school. We serve over 150 girls ages 5 through 14 per day throughout the course of the 350 days a year. And I don't know, it's so close, and it's nothing against the medicinal value of marijuana. It's some of the unintentional neighborhood consequences, as outlined by the police department, that we are afraid of being in such close proximity to a place that, while no, not a school, serves the exact same population in large numbers for quite a large portion of the year. Thank you.
David Hughes, followed by Randy Ress.
Good afternoon, David Hughes. I'm speaking on behalf of the Santa Barbara City Housing Authority as one of its commissioners, and we were before your Planning Commission last week on the matter just mentioned by Mr. Bondurant. Mr. Skamanski, our Assistant Director, is also going to speak. I'm going to make 3 points, 3 requests. Our first request is that final appeal go to the City Council. I know you will hear from your Planning Commissioner members who will appreciate that. This is a very complicated area, complicated ordinance. It's a policy issue, and so we think when there are appeals, the final appeal authority should be the City Council, not the Planning Commission. Second, we would urge you to change your exceptions, which are now limited to parks and schools, as Mr. Bondurant has indicated, to also include what we would call buildings that have permanent youth-related activities, and that can include Girls Inc., Boys Club, youth centers, YMCA. They're the same age group as schools. They have the same susceptibility to influences. The same ideas for which you wanted to protect schools apply to those groups. And right now, the ordinance is so narrowly drawn, it doesn't cover those areas. So we ask you to have your exceptions increased to include that. Lastly, we join with a lot of people who have difficulties with these dispensaries being in residential areas. And we read your staff report. We can see the wisdom whereby the 500-foot rule did not apply to residential areas close to a commercial area, because then it would preclude certain dispensaries being in areas like State Street, et cetera. Our belief is a solution to that is to have location limitations and have the dispensaries within what you would define as commercial strips throughout the city and within reasonable boundaries of commercial strips, such as San Andreas, the Mesa, State Street, Milpas, et cetera. The area, for example, around a lot of the housing authority buildings is almost predominantly residential, but if a commercial zone is within 500 feet of some of our residences, you could have a dispensary within, as Mr. Campanella said, anywhere from 16 inches to 200, 300 feet of a residential area. So I think the solution is not to look at the zones in general, but create commercial strips in the city and areas within reasonable boundary of that where you have your dispensaries. Thank you.
Mr. Rouse.
Mr. Chair, committee members, good afternoon. I'm here as representative of the Government Relations Committee for the Downtown Organization. We recently convened a meeting on this very subject. The attendees included Danny Caddo, law enforcement's representatives from the Santa Barbara School District and School Board, as well as dispensary operators. This meeting was inspired initially by commercial real estate owners as well as their agents who were alarmed at the immense demand for these properties, people willing to pay as much as up to a year in advance in cash to rent facilities. It was kind of a red flag. It's clear that the current ordinance has some ambiguities, and that serves neither the opponents of the situation nor does it serve the people who want to run legitimate dispensary businesses. The 500-foot barrier is clearly inadequate. I have a statement here from Bud Andrews, who is the Administrator of Safety, Welfare, and Attendance at the Santa Barbara School District. And basically what Mr. Andrews said was that in the 08-09 school year, There were 178 secondary suspensions for controlled substance, the majority of which had been marijuana, which represented about 890 days of suspension. Based on interviews with student users and sellers going through the disciplinary process, the marijuana originates either directly or indirectly from medical marijuana dispensaries. Dr. Sarvis, who is here, and I'll let him speak for himself, shares a similar concern about the proliferation of dispensaries around school areas. Your neighbors, the businesses, the cultural district, and educational communities are not satisfied with the status quo, and they're not satisfied with what they've been told to let the current ordinance work. It's not working for everyone. So we're looking for leadership, and they're not looking to play cop and have to be the people to report to zoning what they feel are violations. Most people that approached me on this issue are non-ideologues. Matter of fact, most people I've talked to actually voted for the state initiative, believing that there is compassionate use for this product. The unintended consequence is what we have in these small municipalities today, which is why other municipalities have gone forth and had moratorium. We have some details in mind, but I'm just going to boil it down to two. Number one, please consider an immediate moratorium to give this ordinance a chance to evolve around other solutions that other communities of our size or larger are seeking. Number two, close immediately those dispensaries that are operating outside of the law and outside of the enforcement ordinance. We would like you to invoke the spirit of the initial initiative with the state and not give in to the financial demand that these dispensaries represent. Thank you.
Palvik Waddell, followed by Alina Kitson.
Good afternoon. I was here when the original ordinance was started, and this place was empty. There was really no problem before the moratorium or when the or afterwards. One of the issues I raised was that Santa Barbara, by its character, does not want ostentatious clinics. They voted for Measure P, strongly in the state initiative, but they don't like these things in their face. That's not part of our character. We don't want our children pointing at it, but we do want to be compassionate. Now, what the ordinance did by being so detailed that requiring signs, requiring windows, requiring parking space, requiring security, it created something that was not there before the ordinance. It was done by social advocates. It was done on the low, and no one was complaining about it. Now it's become a big business. People coming from out of town, and the original people who had dispensaries can't afford it. It's so daunting as it is to add more of an ordinance makes it more difficult. And I would only ask that for those of us who have been trying to put together a clinic under the new ordinance, that these new barriers are not put in the way. Thank you.
Alina Kitson, followed by Jeff Rowland.
Hi. I also live in a mixed-use building in downtown Santa Barbara where I have a residence on top of commercial. I'd also just like to voice that I am concerned about the current ordinance not including language that covers that proximity where we're right on top of a commercially zoned area that would allow dispensaries. But again, we're that like 16 inches away from the possible dispensary. That's where families and kids live as well. Thank you.
Jeff Rowland, followed by Sharon Byrne.
Hi, good afternoon. I also live in the Paseo Chapala complex, the mixed-use building, and I'll just second what the other people have said. I believe that it was just an oversight in the ordinance that particular situation has not been addressed. It's pretty clear to me that the intention of the ordinance is that these establishments not be allowed in residentially zoned areas, and I just think it was an oversight, and it's something that very much needs to be addressed. I mean, we live in that building, and if a dispensary is allowed in the building, it basically means that the dispensary is in a residential building. We have mixed-use parking. It'll be a real problem. I used to live in Oakland, and I worked in a neighborhood which was named Oaksterdam because there were so many dispensaries in that neighborhood. It got out of control. The city eventually basically shut all of them down. It wasn't so bad working in that neighborhood, and I actually support, medical marijuana in concept. But, coming out of my office and being harassed by people who want to resell the stuff they just bought out of the pharmacy, having people hanging out in the parking lot. We had to hire a security guard to manage our commercial parking lot because we couldn't actually park in our spaces because there were constantly patients parking there. So, I think the potential nuisances of these establishments is not just anecdotal, it's real. And it's not quite so bad having to live with those nuisances. You can go home when you're done with work. But, when you work with them. But if you have to live with that, it's going to be totally unacceptable. And your police department is going to be very, very busy responding to calls all of the time. So please address this issue.
Sharon Byrne, followed by Patrick Formey.
Good afternoon, committee members. Thank you, first of all, for an excellent report from the staff. I'd like to commend you on the thoroughness of that. I'm also pleased that they mentioned in the staff report several of the provisions that a citizens coalition of East Side, West Side, and Downtown Neighborhood Organization has put together a revised ordinance which was submitted to committee members earlier. Some key caps and some key provisions of that ordinance were already mentioned today, notably caps across the city, protecting the vulnerable, such as the Girls Inc. and Housing Authority recovery projects, an RFP process to attract the best dispensary operators to this city, and some additional items such as good neighbor policies for dispensaries to act as good neighbors within the neighborhoods in which they locate, and cost recovery provisions so that dispensary operations are at the very least budget neutral, if not positive, for the city. We'd just like to ask you to please consider our citizen revised ordinance and adopt all of it, if not most of it. Thank you.
Thank you. Patrick Formey, followed by Skip Szymanski. Okay.
Thank
Go
you,
for it,
Chair
Skip.
and committee members. Skip Szymanski with the Housing Authority, City of Santa Barbara. I, too, would like to commend staff. They've done a great job in reviewing this ordinance and actually implementing it. I won't repeat what Commissioner Hughes had brought to you. I do want to note that 631 Olive Street, which was approved the other day, which the Housing Authority appealed strictly because of its location, is a 900 square foot residence. It is being asked to be broken in half with a residence in the back and the medical cannabis dispensary in the front. So I don't think you can get any closer than that. The Housing Authority is concerned about its special needs population, its family housing, where we have concentrations of youth in its family apartment complexes. I do note that our federal housing properties do prohibit marijuana regardless of the state of California. So we have a bit of a conflict there. We support the consideration of youth centers and so on, and Housing Authority properties with special needs and youth. We would like to see more discretion for the staff hearing officer. We could see at the original staff hearing officer hearing, it was a difficult situation. So thank you, and we appreciate your consideration.
Skip, can I ask you, I mean, what is the Housing Authority's recommendations? Are they what Mr. Hughes just went through? And
yes, what Mr. Hughes went through. In addition,
you want a buffer from Housing Authority facilities? Okay.
Yes, in general, and if the staff hearing officer has some discretion, if we have a 3-unit senior complex, we're probably not going to be impacted. I don't want to make that decision here, but certainly there's a difference between that and a 28-unit apartment complex that's all housing, where it's predominantly youth. We have special needs. We were just approved with a complex at 400 block of East Coda Street, and this is 600 Olive Street. That will be special needs. It's well within a block, and it's going to pose a conflict for us. So we're looking for the support of the Ordinance Committee to understand our situations.
So, Skip, I didn't tell this to the citizens, and I'm probably interrogate any school personnel that also comes up here and tells us the reason why we have a concentration right now is because we had such severe spatial restrictions that there was only 4 places left in the city. If you want us to add more spatial considerations, there will be even less places in the city. So I would challenge, especially government agencies or quasi-government agencies like yourself that is giving us recommendations, tell us where you want to put them, or tell us that you want to ban, because further spatial considerations would essentially be the same thing unless you can identify the place spatially where they would go.
Okay. At this point, the commission would give us guidance in that regard.
Right. You don't have to figure that out today, Skip.
Okay.
I just wanted to.
Okay. Our guidance from the commission at this point was that the 631 Olive Street location was objectionable by the housing authority.
Sure.
So, okay. And
Okay.
we'll follow up in the next meeting.
Thanks, Skip. Patrick, followed by Britta Bartels.
Try to be Skip, but you got me, Doss. I just wanted to address briefly the Ordinance Committee and also the citizenry on a couple aspects of medicinal cannabis. One is that most people aren't aware that the U.S. government has taken out a patent on cannabinoids as antioxidants and neuroprotectants. It's assigned to the Department of Health and Human Services, and you can just Google the patent and check that out just to make clear that there is medicinal value. There's also, it's grown at the University of Mississippi, and it's distributed to only 4 remaining federal patients. One of them has received over 100,000 marijuana cigarettes to date, and he's doing fine with no lung cancer, and his tumors have been reduced. I did prepare a white paper for the City Ordinance Committee, Steve Wiley, Betsy, and Danny, to take a look at, which addresses the concerns of the resale aspect to specifically minors, and as well as a revenue model for the city. There's a lot of people here to discuss things, so I can talk to you another time privately, and we'll let it continue at that.
Thank you, Mr. Formey. Britta Bartels, followed by Naomi Green.
Hi, my name is Britta Bartels, and I would like to mention something today that hasn't been brought to your attention so far. I would like to mention that there is a difference between the needy patients and the kids that go to the dispensaries to use this drug, which I would still call a drug for recreational purpose. And there is a lot of resale going on, and that's what we heard especially from Mr. Martel today. And therefore, I would definitely encourage people to realize that this is not just like a healing purpose herb, that it's also a drug that has been abused for years or decades, and people still think it's supposed to be turned into some medicine. And every time when I hear people talking about medicine, I would not just call it medicine all the time, since there is an abuse going on. And we see that it's not just about drugs. We already have alcohol available to the kids, and I think if we facilitate the dispensaries all over town and we don't put a cap on just 4, even just 1, I think that it is possible to turn the dispensary into some pharmacy that is regulated by the city of Santa Barbara, so we would have it as like a facility for healing and not for recreational abuse. And that would also decrease the cost for recovery when we don't have to hire more police officers to track down all these people that are attracted by the crime that is associated with drugs and the distribution of drugs, no matter if they are legalized or not. And that's why I think it would save us actually money if we don't have that many dispensaries. And I don't think we should think about the taxes, because that money will actually maybe be not legal one day. If the medical marijuana is not a recommendation, it will turn into a prescription drug, and that would be federally illegal, because we cannot put taxes on prescription drugs. And so I think we should still think about taxing it. It might give us some money, but the long term will be that we are sitting over dispensaries, closing, opening up, closing, opening up, and people will just not like to live in certain neighborhoods because of the fact that it attracts still crime. I think that it will never stop because of the security that we have to provide with the dispensaries. Thanks so much, and for listening.
Thank you, Britta. Naomi Green, followed by Becky Betancourt.
Thanks for the opportunity to talk to you today. My name is Naomi Green, and I'm a resident of the East Side, and I was a member of the Citizens Committee for a Revised Ordinance. And I became involved with this in early June, I think, when the 500 North Milpas one was first before the Zoning Committee. And as the summer has progressed, I'm both encouraged and discouraged. Encouraged because I see it's really become a major issue, and people are aware of it and thinking about it and thinking what to do. And I think that the current ordinance will be revised, at least I hope it will be revised. But also unhappy because even as we go along, there are more and more dispensaries. And I looked at a map of Santa Barbara, and I see at least 10 dispensaries in my neighborhood. 10. So that's more than half of all the dispensaries in town. And I actually think there are more than that, but these are the illegal, non-conforming, permitted ones. But I think there are more than that. So again, from the beginning, I've been saying, I think in a socially progressive city, to target a fragile neighborhood is intolerable, and that's been my argument from the first, and that's still my argument. And so, to that effect, I'm asking you to please, when you revise the ordinance, think in terms not only about caps for the city as a whole, but what to do about neighborhoods. And it may not be a high crime area, I mean technically, but I think if you talk to residents of the East Side, there's a perception that there's certainly more crime on the East Side than in other neighborhoods of the city. So for that reason, it's fragile, and for other reasons too, and I'm sure you're aware of them. So thank you very much.
Thank you, Naomi. Becky Betancourt, followed by Roseanne Crawford.
Good afternoon. My name is Becky Betancourt. I'm a concerned East Side resident, and I feel that the city officials and all the candidates that will be running for office should go over the medical cannabis dispensary ordinance with a fine-tooth comb. I also feel that the number of dispensaries that eventually will be operating in our city will reach a level that will create problems in all sectors of our city. Do something about it before it all gets out of hand. I support the Citizen Revised Ordinance. Thank you.
Thank you, Becky. Roseanne Crawford, followed by one of those candidates, David Pritchett.
Roseanne Crawford. I'm very pleased that the ordinance pertaining to dispensaries is under question for revision. I am perplexed that the Planning Commission is the venue that has had total control over the approval of all the permits for these dispensaries. The dispensaries, illegal by federal law, do change the character of neighborhoods they are located in. People in whose community directly affected, as well as schools, parks, and businesses, should be able to voice their concerns directly to you as City Council as a community process. I support a moratorium. Thank you.
Mr. Pritchett, followed by Bob Hanson, another one of those candidates.
Good afternoon. Good meeting management so far to get everybody in. Again, as the chair announced, I'm David Pritchett, running for City Council, but more importantly, a participant in the East-West Neighborhoods Coalition that we heard Sharon Byrne mention. Overall, somebody's making a lot of money on the pot stores in Santa Barbara, and your ordinance is a way to get a handle on that so it no longer becomes a financial burden for the city. As we all know, revenue is a major problem. This is an opportunity to tighten that up in the coming years. It's not an immediate solution, but this draft revised ordinance that you all have received by Sharon Byrne and Tony Vassallo as the authors has lots of great ideas. For instance, the city attorney should review it, of course, to feel comfortable, because we know we like to use precedent that's successful elsewhere. But it has, this ordinance proposal has some pretty innovative solutions, and if our attorney doesn't feel comfortable with those, well, we're not in comforting times, and we might have to be a lead in the state of California. For instance, there's a proposal to do background checks on the owners, operators, and investors of the pot stores. That's pretty innovative. And you all might want to have the City Fire and Police Commission take a look at least at that provision. Their agenda is pretty nimble, and I'm sure can do it in October with the idea for background checks. Obviously, we need to redefine what schools and youth facilities are. That's a major, major loophole. And use the city's geographic information system, the type of maps we saw earlier. The GIS can test all these exclusion variables that can make more and more potentially of the city ineligible for the location of a marijuana facility. But on that point, instead of using that as exclusion, 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 treat the new stores, as the ordinance outlines, like a concessionaire to the city. Have very rigorous criteria to make the operators come to the city and say, here's what we're going to do for the city to run a tight operation and give full cost recovery. Use it as a concessionaire approach for the operation, not just micromanaging ineligible sites.
Thank you, David.
Thanks.
Bob Hanson, followed by Dave Homeless.
I agree with David, and a friend of mine wants to speak, so I'm going to yield my time to her.
Hi. When Proposition 215 passed, there was no limitations as the people voted, like 65% overwhelmingly. Cannabis should not be limited. Patients need their rights. They need access, just like any patient needs access to their medicine. There should be no discrimination against people with disabilities. Whenever you have something of value, there's going to be a crime element. If we allow the free market to make it happen, that will bring the price down, and it will make the crime element leave. We also know cannabis is not a gateway drug. This has been proven, and it was in almost all children's medicine until the companies that didn't want to compete with cannabis lobbied to make it illegal with no ill effects. It didn't have any ill effects. I think the solution is stop lying to the kids about drugs, lumping them all together, saying they're all really dangerous. Tell them the truth, which ones do what. Like DARE is going to, programs like that are going to lie to the children. I say stop lying to the children, because when they find out that it's not dangerous, they're going to say, well, let's try this, let's try that, let's try everything, because they lied to us about cannabis. And if we pretend it's this great big deal, it's just going to be more of an attraction to children to try. Thank you very much.
Thank you. Dave Homeless, followed by Forrest Buckman.
Shouldn't we be talking, let's see, alcohol, cannabis, which does the most harm to this community? The way I see it, alcohol's hurt this town more than cannabis has. Maybe we should shut the bars down in Old Town at 9 o'clock at night. We know that ain't going to happen. You close the dispensaries, you're going to bring all the old street dealers out of retirement. Somebody's going to make a whole lot of money. Right now, as I see it, the police have pretty much got a handle on things. But you close the dispensaries, you're going to have another crime on the street. And it was here before. You opened up the dispensaries. It's more or less disappeared. I say leave them alone.
Forrest Buckman, followed by Joe Allen. Thank you, Dave, by the way.
I'd like to make a comment from a commercial realtor's point of view. As Danny Cato pointed out, moving 500 feet to 1,000 would really restrict the options for these dispensaries that will be in our community. So just want to note, I am against expanding it beyond 500 feet. Because again, it would eliminate most locations, and it's already here in the community. And
Forrest, why don't you bring up that mic, because you're real tall. And so, sorry.
Like that repeated?
Sure.
From a commercial realtor's point of view, extending the distance of 500 feet to 1,000 would basically eliminate any opportunity for dispensaries or keep it very minimal. So I just want to note 500 feet to 1,000. 1,000 would be a bad idea.
Thank you, Mr. Buckman. Joe Allen, followed by Ray Maboo.
Good afternoon, committee members. I'm Joe Allen. I represent some of the dispensary operators in town, among others, although not all by any means. It seems to me that David Hughes, the attorney who spoke somewhat earlier today, made a sensible suggestion that would solve most of the neighborhood concerns. He advised you to look at the map of Santa Barbara and select some commercial strips where dispensaries are allowed, and then simply say that they are not allowed anywhere else in the city. That solves all your distance requirements except the spacing of dispensaries from one another within those commercial strips. The theme that I've heard over and over again from people who are concerned about tightening the ordinance in various ways is that something bad that hasn't happened yet may be going to happen. Before you adopt too many ordinance amendments, you should look at how tight the ordinance is that you already have. Apart from geographical questions, the requirements for a successful, permitted, legal dispensary under your ordinance right now involve the tightest operational and security requirements that you impose on any kind of business, including pharmacies that have hundreds of thousands of dollars worth of painkillers that would command an enormous amount of money on the open market. You don't require security for pharmacies or for liquor stores or for banks that approaches the degree of regulation that you have imposed on these dispensaries. Bear in mind also that the easier you make it for a specific dispensary to comply with your regulations, the easier you make it for native small business people in Santa Barbara to get into the business. If you raise the barriers to entry by raising the expenses, you will get to a point where out-of-town investors are the only applicants you have. I don't think that's really what you want, but it would be the unintended consequence of making it too expensive. I don't know where that break point is. You're not there yet. All the people I represent are entirely local, but I can see the possibility that that might happen. Finally, when I heard Captain Martell of the police department discussing calls for service, what I heard is that compared with bars, liquor stores, or virtually any other kind of downtown business, dispensaries have a call for service proportion that is amazingly low. One dispensary over on Parker Way had 8 calls for service that were actually 4 different people calling in about 2 separate incidents. None of the other dispensaries that are operating lawfully at the present time have had any calls for service at all in the last couple of years. None.
Joe, I need to ask you to wrap it up.
You bet. So my suggestion is this. I thought the neighborhood associations getting together and studying the problem was an excellent precedent. I suggest you consider the question of a citizen advisory committee called out by the council, structured so that it includes existing dispensary operators and applicants, people from police and fire, and people from the neighborhood associations and from the downtown organization. Let's see how many of the fears are supported by facts, and let's try to keep in mind that many of the things people are afraid of, in fact, have not happened. And with the security provisions you already have, are not likely to happen. Thank you.
Ray Mahboob. Ray Mahboob, followed by Shreen.
My name is Ray Mahboob, and I am the owner of the ground floor retail at Paseo Chapala. And I did hear some concerns by the residences living upstairs, including Mr. Capanella's concern, the same individual that sold the commercial spaces to me. When they sold the commercial space, there were covenants in there, and some of them like no tattoo parlors, no bars, and I am definitely under the guideline of going by the rules and regulations of the association. And just to give you some background, I brought in Esau's Cafe and Silver Greens into that same project, and that was a big concern with all the residences living there. As a matter of fact, a number of the residences protested their beer and wine license. So they definitely, if they had it their way, they would like to see the whole place vacant or occupied by office tenants, and that's not a reality. If you know, it's built for retail, and I'm planning on having retail tenants. In regards to the tenant that's planning to take the space, it's called the pharmacy. I considered them because I find them to have not just cannabis being sold at the premise. It's a lot of Chinese herbal remedies, and I'm a believer of alternative medicine. And for anyone that hasn't seen the front cover of Fortune magazine, there's an article that says, "Is pot already legal?" And the pharmacy is mentioned in here, with the owner's picture is also in there as well, and speaking favorably. Thank you. All I say is that I support dispensaries that have a good business model, and thank you.
Thank you, Ray. Shireen, followed by Bill Walt.
Good afternoon. My name is Shireen Katapoosh, and I'm here representing both the Fighting Back Community Coalition, a community coalition that's been in our community for more than 20 years, working on substance abuse reduction. And also, as an employee of the Council on Alcoholism and Drug Abuse, I work in the Daniel Bryant Youth and Family Treatment Center. So every day I'm around kids who have drug problems, and I supervise staff who work in the schools with kids who have drug problems. I'm also here as me. I'm someone who's lost people to drug addiction, and my sister is a recovering addict. So I bring all of that to my comments today. What I want to tell you that you might not know is that every couple of years, kids in our schools take a survey called the California Healthy Kids Survey. And when you look at what kids tell us about their marijuana use here, and you compare it to marijuana use throughout the state of California, our kids are using more. Use of marijuana in our community has been increasing for the last few years, and it's higher than the state average. We already have a problem. There's already too much marijuana use happening among our youth. And it's not just experimental use, occasional use, but it's frequent use of marijuana that's been increasing as well, and is also higher than the state average. I know you have a lot of perspectives to consider. And you, like me, want to live in a good community. And this is a good community. And I just urge you to consider the question of enough. A city the size of Oakland has determined that they need no more than 4 dispensaries. We have enough. We have more than enough marijuana flowing in this community, and I'm really concerned about our youth. I'm concerned about addiction. When kids use before the age of 15, they're 4 times more likely to have addiction or dependence in their lifetime. Please, let's protect our youth and limit the number of dispensaries in our community. Thank you.
Thank you. We're going to have to do 2 things. First of all, the 2 folks who put in their slips after we started taking public comment, we're going to have to leave you for the next time on the 29th. That's Ken Rivas and Bonnie Raisin. My apologies to that. We are going to have to limit public comment. We still have 10 more speakers to 1 minute, and that also means that we only get 1 minute each. Mr. Walt, followed by Bud Andrews.
I have some articles here about several cities that have adjusted their laws so dispensaries could exist there. I'd like to do that. There was a woman on CNN recently who spoke before the Congress on the benefits of medical cannabis and ADD and how it does help children. I think that there ought to be a citizens committee to help with this. I personally got petitions in a neighborhood of some 643 signatures, and only about 11% of those were against marijuana. They didn't want to sign it, and most of them, the 8% of the 11, didn't want to sign it because they didn't want to put their job in jeopardy. There was a very small percentage of people that were against it. So I think with the violent crime, there is less violent crime on marijuana than and much more in alcohol.
Thank you,
And
Mr. Hall.
I'd like to see more dispensaries than fewer.
Bud Andrews, followed by Mr. Sarvis.
Hi, good afternoon. I'm Bud Andrews. I'm the administrator for Safety, Welfare, and Attendance. You actually had part of a report that I had written to the school board, read to you by Mr. Rouse. The only opinion I want to express here today is that I urge you to strongly consider the recommendations from the school board that were sent to you on a letter September 8th from Dr. Sarvis. But more importantly, I wanted to identify very quickly some facts for you. The public school system does not recognize medical marijuana on its campuses, certainly not in California. And as a result of that, we have significant numbers of discipline issues. In my title, Administrator for Safety, Welfare, and Attendance, essentially means that I deal with all the serious student issues in the residual effects of marijuana, in a similar vein to Captain Martell in the police department. I was impressed and pleased to see that Danny Cato had included many of those options from the school board into his presentation this morning.
Mr. Andrews, we're going to have you wrap up.
Very good. Here's Dr. Sarvis will be adding some extra comments that I haven't given.
Thank you. Mr. Sarvis, followed by Eileen Mira.
Good afternoon, council members. I'm Brian Sarvis, Superintendent of Santa Barbara School Districts. I'm here on behalf of 16,000 students in our schools. We have a problem, and that is that far too many of our students obtain marijuana from these dispensaries and either come to school high or come to school and try to sell it to other students. Students who are high are not students who are learning. That's something bad that has already happened, and I don't think we should pretend otherwise. Because of the proliferation of dispensaries, the Board of Education for the Santa Barbara School Districts directed me to advise you the need for further restrictions. I believe you have a copy of that letter. It asks you to do things like providing prior notifications, increasing the distance from school, regulating density. Just the authorization of a dispensary just 2 blocks from one of our junior high schools has posed a significant problem. We have a lot of students walking past that school. In short, there are too many dispensaries. They are too accessible to our students. And I urge you to impose first an immediate moratorium, to close those clinics that are not in compliance, and third, to revise the ordinance. Thank you.
And one request, Mr. Sarvis. Again, you saw the map that unless you want all of the dispensaries to go in the Brinkerhof, that if we extended it to 1,000 feet from all schools, we wouldn't know where to. So I would love it just for clarification from your board, whether you are asking for a ban or whether you have any commercial areas that you would recommend that it be allowed in.
I'll be happy to take that back to him.
Thanks, Mr. Sarvis. Eileen Mira, followed by Gail Hadams? McAdams.
Come together because we're co-owners of a unit. Hi, I'm Eileen Mira, and Gail and I own a unit at Paseo Chapala. And we're just most concerned with the zoning aspect of the C2 and the CM. I just want to make it very clear, when we purchased our unit, and I'm sure this was the case for Ray in the commercial space, we thought we were going to be in a residential, peaceful building. We're actually landlords. We rent out our unit. And as a matter of fact, our tenant has decided to leave because he's quite concerned with what's going on and that a possible facility will go literally 16 inches below our unit. So we just object to that. We think maybe that wasn't thought through in regard to the zoning, being that we are residential 16 inches above and commercial downstairs. Gail?
That's it for me, too.
Thank you. David Bierman, followed by Pam and John. I don't see David Bierman. So Pam and John Johnston, followed by Joanna LaForce.
Yes, thank you very much for hearing from us. We're residents of South Olive Street, and really just have a couple very quick points to make, one of which is I think it would be a very good idea, and we would strongly recommend a moratorium. Clearly, this is exploding out of control and needs some further thinking and refinement. I think one of the big issues we have is that it's even more out of control by the fact that we have a lot of people who have moved forward in implementing illegal and non-conforming facilities, and we should just immediately shut them down because it's exacerbating a problem. And then the third thing is I would like to emphasize that I think the suggestion about limiting the facilities to business districts is a great one that we would support. And the reason why is because the fact that the ordinance really sets up a situation where people can easily come in, anyone, there's no barriers to entry. We really have a situation where we don't have stakeholders in the community that are really running these in a lot of these cases. To set up a facility at 631 Olive Street in the front of a building with a couple bucks, that's not a stakeholder. And the big issue that I foresee is that these are very, very vulnerable neighborhoods to crime. And if we're going to do something like this, I think putting it out in the open where there's a lot of traffic, a lot of other governance besides these non-stakeholders, ensuring that this is managed properly is the right way to approach it. So I would strongly recommend a moratorium. Thank you.
Thank you. Our last speaker will be Joanna LaForce.
Hi. I had a lot more to say, but I'll talk fast.
Don't worry, I won't cut you off exactly 60 seconds.
Okay. I have two concerns. One, as a resident of Santa Barbara, I've been a resident of Santa Barbara for 17 years, and I'm concerned, as the citizens are, about proliferation and the negativity that's gone around, and a lot of it justifiably so in many cities regarding dispensaries. It is time for regulation. And I'm very much in support of that, and I like some of the issues and some of the things that the citizens have recommended. My second concern, obviously, as an applicant for medical cannabis collective dispensary in Santa Barbara, I believe that education is the most important thing, and again, we do need to look at the actual versus perceived issues of dispensaries. Both are very important. I do support a cap, but I feel that 4 will limit to what we have right now as far as the 4, licensed one. It doesn't allow for this, the good dispensaries that were here beforehand. And also limiting to 4, again, doesn't allow the option for people that are within the system. And I think what would happen is it'll be contradictory to what the citizens really want to limit it to 4. A moratorium, obviously, I'm concerned. I put in my application in May, but I've had planned and done my homework for about the last year and wanted to be a part of Santa Barbara. So I think if there is a moratorium, it needs to allow the people that are in the process right now to be able to complete. Okay.
Thank you,
I also
Joanna.
sent some recommendations to you, so I hope that you will look at those as well that address many things. Just a side note on Oakland, with 4 dispensaries, you have thousands of people going through those dispensaries in a day, and it makes more of a problem than people realize. The one dispensary in Oakland has over 1,000 people that go through their dispensary a day, so that's not a really good suggestion either, or concern.
Thank you, Joanna. We will take very, very brief comments from committee members if they so wish. Do either of the committee members want to make a note? Mr. House, no?
Yeah, real quick. Mr. Martel, we have already a prohibition against dispensaries that are not licensed. Is that accurate to say? The dispensaries that are not licensed are not allowed. They're illegal. They're not allowed to be operating, except for perhaps those ones that are non-conforming that were in before, right? We've already addressed that.
That's correct.
So if somebody has put up a dispensary or wants to and does it, it's already against the law, and we will enforce that.
That's correct.
Thank you very much.
And I also just wanted to make a brief statement. What I hope, and next week, or not next week, but on the 29th when we continue this meeting, again, we'll probably do it at noon, maybe a little bit earlier, might be called for. I am very interested in hearing from folks even a second time, especially because I think what a lot of people's frustration is about some of the illegal and non-conforming dispensaries. And the ones that have been approved very recently. Only one of them is currently in operation, and that has been for a short period of time. The problem with creating larger restrictions on the new ones, the ones that are regulated, is it will entrench the non-conforming and illegal dispensaries. It will. It will make them continue to make a lot of money. It will make them continue to operate until they are closed down, which, according to this ordinance, is another couple years, 2011. Those non-conforming do not have to come into compliance until 2011. So if we enact a moratorium or we do something very severely restrictive on issuing new permits, we will entrench and make sure the non-conforming ones stay in operation and continue to make money till they are required to end in 2011. I'm not sure that that's the intent of what people are asking for. And so I'm asking people to think this through, because this ordinance committee definitely, I think, is willing to make a tougher ordinance. But I'm asking that we do this in a functional manner that promotes dispensaries that are good neighbors and punishes and gets rid of ones that are not. And I would argue that especially the illegal dispensaries